Thank you, Jeff. Thank you. And hello, everybody. Good morning. I've got some slides, so I'm just going to launch the screen share, which will hopefully work. Brilliant. Thank you for joining this session this morning. I hope you're all well. I just want to say Jeff has worked very hard behind the scenes to set all of this up, and so I hope you find it helpful. Let's crack on, and I apologise to anybody who was at the Making a Will presentation just about an hour ago, but I am just going to say a few brief words about me and about the firm I work for very quickly. I am a partner in the private client department at Lodders, and I work mostly with individuals who want to make wills, who want to make powers of attorney, or who are dealing with the Court of Protection and applications that go through that institution. Lodders, the firm that I work for, has been established for over 240 years now. We've currently got 4 offices in Stratford-upon-Avon, Birmingham, Cheltenham and Henley and Arden, and I'm currently broadcasting to you from sunny Stratford-upon-Avon. I'll try and avoid any Shakespeare quotes for you. Now, to the matter at hand. What I want to go through with you today is an introduction to what lasting powers of attorney, or LPAs, are, why they're important, what you need to think about when you're making LPAs, and some of the processes and procedures that apply. So the very first thing to say, what is an LPA? An LPA is a legal document that lets you appoint one or more people to help you make decisions, or to make decisions for you when you cannot make them for yourself. There are 2 types of LPA. One of them covers decisions about your financial affairs, and the other one covers decisions about your health and welfare. And they are 2 separate documents. In Scotland, they have a slightly different system. There is one form, and you can choose whether it applies just to finances, just to health, or to both. But here, in England and Wales, if you want to have attorneys making decisions about your financial affairs and about your health, it's 2 separate forms that you have to fill in. Now, LPAs do a very good, useful, positive job. They give you more control over what happens to you if you have an accident or are ill and are either temporarily or permanently left unable to make decisions for yourself. It's a way of getting people that you trust in place to represent you if you're finding it difficult or impossible to make those representations for yourself. Now, the interesting bit, this is the bit I like, and it's the bit that makes everybody go to sleep, so it's probably a good thing that I can't see any of you nodding off. But you need to have a little bit of background about how LPAs developed, I think. I think it is important. So we have always been able, legally, to make an ordinary power of attorney. That's a very simple document. It's 1 page, and it's a way that you can give your signing authority almost to somebody else and allow them to carry out certain functions for you if you are, for example, out of the country. It's useful in business transactions and things like that. If there's a contract that has to be signed and you're not able to do it because you're absent, you can give somebody else the authority to do that signing for you. The thing with ordinary powers of attorney is that if you, as the donor of the power, become mentally incapable, so you have an accident and you're unconscious, the person that you've appointed under an ordinary power of attorney no longer has the right to sign things on your behalf. So just at the point where perhaps it would become most useful for them to be able to keep doing things for you, they've lost that ability because you have not got mental capacity. So in 1985, I think it was, they introduced enduring powers of attorney, or EPAs. And they were, again, relatively simple documents that allowed you to nominate a trusted person or people to make financial decisions for you. And the idea was that if you became mentally incapable, your attorneys would lodge that EPA document with the Office of the Public Guardian, have it registered and activated in effect, and then take over running your finances for you. Unfortunately, with the way that the system was set up, it was very open to people taking advantage, and there was a lot of financial abuse taking place. Enduring powers of attorney do still exist, and ones that people have prepared over the years are still valid. But these days, following the Mental Capacity Act 2005, if you want to appoint somebody to make decisions for you, you have to make a lasting power of attorney. And part of what's being built into the lasting power of attorney are more safeguards for you as the donor. It's more difficult, not impossible, but it is more difficult for people to take advantage using a lasting power of attorney than it was under the previous system. And I've mentioned the Office of the Public Guardian, or OPG. They are responsible really for overseeing the whole system. So the Office of the Public Guardian register lasting powers of attorney and enduring powers of attorney, and they maintain a central register with details of all the registered documents on them. And they also look into reports of abuse against attorneys and deputies, actually, but attorneys in particular, and they take action where it becomes apparent that an attorney has perhaps taken a little bit of financial advantage. They can remove the attorney and all that sort of thing. So the Office of the Public Guardian have an important role to play. So that was a very brief history of how lasting powers of attorney came to exist. If you don't have a lasting power of attorney, though, and you lose the ability to make decisions for yourself, it's not the end of everything, because that's when the Court of Protection would be asked to assist. So it is possible for somebody to apply to the Court of Protection to be appointed as your deputy if you lose capacity and you haven't got any attorneys appointed. The deputy is, in effect, a court-appointed attorney. We have to call them different things, otherwise people get confused about what regime you're acting under. So there is a system there to have people put into place to make decisions for you if you lose capacity and you haven't got an LPA. But the process of applying to be a deputy takes a very long time, and it costs a lot more than making an LPA. So it's not perhaps to be considered the default position. I think the sensible approach is for you to take the decision yourself to appoint people that you trust, rather than leaving it all to chance. And if you do lose capacity, you've got somebody who can apply to the court, but it might not even be somebody that you're terribly fond of. In some cases, I am appointed as a deputy for people who lack capacity, and they are people I have never met. And I am making decisions about their financial management for them. And it's very difficult to make best interest decisions when I have no background knowledge of them. So it's much better for you as individuals to take the choice of who you would trust to make decisions for you if you lost capacity. Being a deputy as well comes with a few more sort of administrative burdens than being an attorney. A deputy has to pay an annual fee to the Office of the Public Guardian, and they have to submit an annual report, almost like annual accounts, showing what's come in and gone out of your bank accounts and things like that, which an attorney doesn't have to do. Now, if we go into looking in a bit more detail at the two different types of lasting power of attorney, that might be quite helpful for you. It will hopefully give you some ideas about the various things that you might need to consider in drawing one up. So the financial LPA, people that you appoint under that document will be given the right to buy or sell property for you. They'll be able to open and close bank accounts, deal with benefits agency and claim your pension for you, deal with your tax affairs, make sure your bills are paid, manage your investments and savings, and they will also be able to make limited gifts on your behalf, things like reasonable sums at birthdays and Christmas and things like that. They wouldn't be allowed to undertake complex tax planning gift strategies that involve shifting lots of your money out of your name. They would need to actually ask the Court of Protection for separate authority to do that. But in terms of running your day-to-day financial life, that's what they'll be able to do. And you can choose within the financial LPA document whether your attorneys can act for you as soon as the document has been registered, or only if you no longer understand and can make your own decisions. And that's an important distinction, because if you are physically incapacitated in some form, potentially just temporarily, if you had an accident that left you unable to sign things, then having your attorneys appointed with the provision to say that they can act for you at any stage means that they can step in and do things for you, like sign checks while you're recuperating. And then once you have recovered, you can take back control of dealing with everything. They can then also get involved should something happen to your mental capacity and your ability to understand. If you limit what your financial attorneys can do to them only being allowed to make decisions for you if you have lost capacity, suddenly you've got rid of a whole lot of useful support. So we would always recommend, bearing in mind, of course, that you must trust your attorneys 100% to start with, we would always recommend that you allow your attorneys to get involved and help you from the moment the document is registered. If they don't need to do anything, they don't need to do anything, but it's nice to have it there ready should something awful happen. They can step in and make sure that things like bills are paid. What you won't find these days, unfortunately, is an understanding local bank manager who will just allow your partner to access your sole name bank account on an interim basis. They don't have that flexibility anymore. They want to see the paperwork. So it is important to, as part of your wider planning, think about this sort of thing and having people that you trust in place able to act for you. The other type of lasting power of attorney is to deal with health and welfare decisions. So these are massively wide-ranging decisions. It can be where you should live, what sort of day-to-day care and support you should have, involvement in the assessments for care and support provision, deciding on social and leisure activities, consenting to certain treatments or refusing certain treatments on your behalf, and just dealing with things like personal correspondence and your paperwork and things like that. This is a newer LPA, so it's only been possible for people to appoint health and welfare attorneys since 2007. I know that's quite a long time ago now, but in legal terms, where we still use legislation from hundreds of years ago, that's quite recent. So we've not seen them being used in the wild, as it were, very much even yet. But I should think that for most people, and myself included, actually it becomes more important, doesn't it, about your health and welfare than necessarily your financial management. If you have lost the ability to make a decision about where you should live or what sort of care you should have, I think it's much more important to have someone that you trust able to make that decision based on what they know about you and how you have chosen to live your life than leaving it to complete strangers. Importantly, under the health and welfare LPA, your attorneys can only ever make a decision if you lack capacity. So there isn't any of that sort of just stepping in to help out on on an interim basis or anything like that. So your attorneys could only decide, for example, where you should live if it's a decision that you can't make for yourself. They can't override your own validly made decisions. That's a concern for some people. So that's not how the system works. And if I just pop up to the bit on the slide there that says consenting to or refusing treatment, there is actually a very important decision within the health and welfare LPA, a very important section where you have to state whether your attorneys can make decisions about accepting or refusing medical treatment to keep you alive. So this is about life-sustaining treatment. And you have to say whether they can do that or they can't do that. And it's a separate sheet within the document. If you cannot understand a decision that needs to be made about life-sustaining treatment, can your attorneys do that for you or not? In most cases, with the documents that I have prepared, I find that clients do want their attorneys to be able to make that decision. They don't want it necessarily just to rest with the medical professionals, but it depends entirely on your own sort of belief system and what you want. So this is the thing with LPAs, they can be structured very much around your own personal wishes, and things about treatment and life-sustaining treatment in particular. Those are incredibly personal decisions and things that you would want to know are in the hands of people who really understood you deep down, I think. So in terms of preparing LPAs, they are, as I've said, two separate documents. You don't have to do both of them. You can just choose to do one. Each form can run to a good sort of 12 pages. So they're quite hefty. And there is guidance available as well from the Office of the Public Guardian about how to prepare the documents. If you were to ask the Office of the Public Guardian to send you both forms and the guidance document, which they will do, you'd end up with a good few inches of paperwork to go through. It's more like one size fits none than one size fits all. They're trying to cover all kinds of potential scenarios within one guidance document. It's not as complicated as the paperwork makes it look. If you wanted to do both types of lasting power of attorney, you might want to consider having the same attorneys in each document, but you don't have to. You can have different people in each document, and it depends on the personalities and the skills of the people you're appointing as your attorneys. Now, we have some cases where clients come in and they would very much like to appoint all of their children as their attorneys. They don't want to leave anybody out because they don't want any arguments or anyone to feel bad in any way. But it turns out that actually one of their children isn't very good with money, and another child lives overseas. And so you might have to say to them, well, thinking about it, would it be sensible for you to have a child who is not very good with money appointed to make financial decisions for you if you lost capacity? Is that sensible? And the child who's overseas practically how are they going to be able to do things like sign documents easily? I know it's easier these days to deal with things remotely. We're having a remote session here now, but there are still sometimes cases where checks need to be signed. And if you have an attorney who's not in the country, then you've got to rely on the postal system to get everything through. So nothing can happen very quickly. It's important to make sure that your attorneys are willing to do it as well. They do have to sign the form as part of the process to show that they are accepting the appointment. But I think before you go to the trouble of starting to draw anything up and write down what you want to happen, ask them if they're happy to take that role on. It's a big responsibility. The thing with LPAs is, unlike wills, you would hope with an LPA that it's never going to be needed. Yeah? Because you might never lose capacity. So you might never need your attorneys to make decisions for you. When you make a will, even though it's horrible to contemplate, you know that one day you will die and that document will come into force. But with the LPAs, you've got this mindset almost of it being like an insurance policy, something that you're putting in place against the possibility of being incapable and needing people that you trust to make decisions for you. Your attorneys would have to be over the age of 18. This can be a sticking point for some people if they've got a son aged 17 that they really want to be included. You can't name them, you can't put them in the document at 17 or anything like that. They have to be 18 or over. And the attorney that you're appointing themselves have to have an understanding of what it is they're getting into, and then, as I said, need to sign to agree to be your attorney. And from your perspective as the person making the power of attorney, as the donor of the authority, you have to be over 18 and you have to have mental capacity. So this is can be a stumbling block again for some people. But you have to understand the document. You have to really know what it is that the document does. And as to confirm this, there is part of the document that gets filled in by an independent certificate provider who states that in their professional opinion, ordinarily, it's normally a solicitor or a doctor who does this bit, and they confirm that they have seen you, spoken to you about the document, and that in their opinion, you understand it and nobody is forcing you to sign it. And that's a safeguard that's been built in to the LPA to try and avoid people being forced to sign something that gives an awful lot of authority away when they don't really understand what it means. Now, you don't have to answer mastermind level questions on LPAs in order to prove that you understand them, but you need to understand the level of authority that you're giving and the sort of decisions that your attorneys are going to be able to make. And then, as I've mentioned, the LPAs have to be registered before they can be used. So once everybody is signed, once you as the donor sign and the attorney sign and the certificate provider signs, the physical form is sent to the Office of the Public Guardian. And they put the existence of the document into a central register, but they also stamp it on every page so that when that document is then presented to, for example, a bank, the people at the bank know that it has gone through the right processes and that they can rely on that document. If they have any concerns about the validity of the document, or if they want to check anything that's in it, if it looks like someone's trying to sneak an extra page in or do something fraudulent like that, the bank can call the Office of the Public Guardian, who will be able to clarify things for them. So registration with the lasting power of attorney is more about getting the document activated so that it's ready to be used should something happen. Now, it's important, I think, and we as a firm will always recommend to people that they register the document as soon as possible, because it can take up to 3 months for that registration process to complete. And what you don't want is to, for example, be in an accident and be unconscious and need your attorneys able to make a decision for you and need them to be able to sign things for you, and they can't because they have to wait for the registration to take place. So this is something that's preparing LPAs is something that you should think of doing while you're absolutely fine. And it's something that you should view as an insurance policy, and they are documents that you should get registered straight away so that if something happens, there is a proper legal form there that can be used by the attorneys immediately to step in and help you when you need it the most. Now, it's important to choose the right people as an attorney. I've said that they've got to be over 18. It kind of goes without saying that they should be trustworthy, but I will say it again, if you have any doubts whatsoever about the sorts of decisions they might make for you, you probably shouldn't appoint that person as your attorney. There's a couple of sort of restrictions again on who can be an attorney in certain circumstances. So if you want somebody to make financial decisions for you, they can't be bankrupt. And if they become bankrupt whilst they are your attorney, they would have to step down from that. They wouldn't be able to continue. And I guess that's just because if they have allowed themselves or found themselves in a situation where they are suffering bankruptcy, they're perhaps not making the greatest decisions about money management, so probably shouldn't be looking after somebody else's funds. In terms of who you choose, there are no rules really. Friends, relatives, professional people, they can all be your attorneys, and you can mix it up a little bit. So one of the flexible things that LPAs can do, you can have a spouse or long-term partner as your sort of first attorney, and you can name 2 children maybe as initial replacements, and then maybe a professional advisor as a final replacement. You can have substitutes, you see, so that you can kind of future-proof the documents as much as possible, and then be sure that whatever life throws at everybody who's involved, you should always have somebody that you trust able to make decisions for you. You can have lots of attorneys if you want to. The most I would recommend that you have is 4. But lots of people appoint 2 attorneys initially, a spouse and a child, or a couple of children, or 2 professionals. And if you have more than 1 attorney, you can say that they have to make all their decisions together, or they can make their decisions independently. And there is a sort of a technical point here. Whereas we again as a firm would recommend, having seen the documents in practice, that if you appoint 2 attorneys, you appoint them so that they can act independently. Now, this is because if you require them to do absolutely everything together and one of them dies, the remaining attorney finds themselves their power, their authority voided. They have been appointed to act jointly with somebody. If they can't act jointly with somebody, they can't act at all. So it's much more flexible to appoint your attorneys what they call jointly and severally. They can act together or they can act independently. And it just means that if something happens to one of the attorneys, the other can carry on. Now, I've mentioned trust. Absolutely, you've got to trust your attorneys. You need to be happy as well that they are reliable and that they have the skills to do the job and the time. Because if you think about it, it's not sort of thing that you can just sort of say, oh, I'll take 5 minutes a day to look after somebody's finances. There's paperwork, bills to be paid. If someone's moving into care, as an example, and you're an attorney who's both dealing with finances and welfare, you've suddenly got yourself a full-time job. So that needs to be a consideration as well. And again, that's why it can be useful to have more than one, because they can share the burden. But But reliability and having the skills to do it are fundamental. The problem with lasting powers of attorney, and the reason I talk about trying to make them as flexible as possible and future-proofing them as much as possible, is that once they've been signed and registered, you can't start making changes to them. If anything changes and you want to have different attorneys, you have to undo the documents, you have to revoke them, and you have to make entirely new ones, which comes with a time and cost aspect. So we try and give it as much thought beforehand before we commit anything to paper and before we get to the point where it's registered, to make sure that whatever circumstances arise, you are covered. So what are the benefits? The benefits of making LPAs? Well, they allow you to trust. They allow you to appoint people you trust to make decisions for you rather than leaving everything to potential strangers. I think that the peace of mind that offers is immeasurable. I can't put a price on it, actually. I recently had an operation, and before that happened, I made sure that I got all my powers of attorney in place because, I work in this field and you see that things go wrong. Now, luckily, nothing did go wrong, but the peace of mind that knowing that I'd appointed an attorney who I trusted, should something happen to me during that process, meant that I was only anxious about other things to do with the surgery, not about that. I knew that whatever happened, everything there was in place. Powers of attorney as well, like I said, they're very personal documents, and they involve thinking about lots of really importantly fundamental personal decisions. And if you are talking to people who you might want to be your attorneys about how they could approach the decision-making process, well, that means you're starting some really useful discussions with your loved ones, with the people that you trust, about how you want things to be approached in the future. If you're appointing a welfare attorney, for example, it would be really, really helpful for them to know whether you would ever be happy with a move into a care environment, or whether you would actually really want to be looked after in your own home for as long as possible. Your welfare attorney would also want to know perhaps how you feel about being on life support, or what you think about quality of life. If you were seriously injured or very unwell and potentially coming back from that, what are your views on quality of life? What would be bearable and unbearable for you? Because they might be being asked to make some really fundamental decisions based on that, and it's no good trying to guess. And the final benefit with LPAs is making things easier in the future for the people that you appoint as attorneys, because there's less chance, not no chance, it depends how your attorneys behave and a couple of other things as well, but there is less chance that the Court of Protection will need to get involved. And the Court of Protection does a wonderful job, and I don't want to come across as actually being negative about them. They have a really important role, but the workload that is generated for them means that everything that goes to them takes a very long time, and that isn't ideal for most people who need day-to-day decisions made. So if you can reduce the chance of the Court of Protection needing to be involved, that's better for you and the people that you are entrusting to make your decisions. Now, it is possible for you to access all of the information that you need about LPAs and all of the systems that you need to make LPAs by going online. So the Office of the Public Guardian has a dedicated site that will ask you the questions that you need to type your answers into to produce lasting power of attorney documents. They are not forms that require the involvement of a solicitor. The only person that needs to be involved with them, apart from you and your attorneys, is somebody that you identify as an independent person who can certify that you understand them. So you can go through the whole process of drawing up the documents without having to incur legal fees or anything like that. And if you do it that way, the only potential cost that you've got is the registration fee that the Office of the Public Guardian charge. That's currently £82 per document. And so it can, it can add up. If you're a couple and you're each doing both documents, that's quite a significant outlay in any event. But you can do the documents yourself and go through that process, pay the registration fee, and then you've got the form. It's not something that I want you to think that you have to have legal advice about. If you have perhaps slightly more complicated wishes, or you want to have some very bespoke guidance in the document, or you want to limit what your attorneys can do in some way, then actually, yes, perhaps it would be useful for you to come and take some legal advice. But I don't want you to think that that's the only way that you're going to get a power of attorney in place.